Fulton County courthouse camera system. It's kind of a 3-box. Luckily, I'm cross-eyed. I can see all of them at once. And we're keeping an eye on it because Donald Trump, former President Donald Trump's attorneys, will soon be making arguments in front of the court to dispose of the case in which the RICO case, in which he's accused of various acts in relation to the election of 2020. Katherine Lizardo is here rejoining us, Natalie Whittingham-Burrell. So, Katherine, we didn't get a chance to chat about this. You can see the 3-box there. There is a judge on the bench, so we could abort this and jump in any moment. Katherine, what are your thoughts on this First Amendment argument we expect to hear?
You know, like what Natalie mentioned initially, it's just something that Trump's lawyers have to present in their demurrer. We know that that same argument has been stricken down by that judge as well against the other co-defendants. So they have to do this for appeals purposes. And also, it might be legal malpractice if they don't pursue it. So this is a strategy, a procedural strategy at this point, but likely going to win their demurrer at this point.
Yeah, it's Judge Scott McAfee on the bench there. I did check with the Magic 8 Ball, and it does say all signs point to no in terms of whether this will be granted or not. So let me follow up, Katherine, and ask if you think there are any good defense arguments that might be presented in this case.
Not at this stage of the litigation or this trial. It's the early part of the stages. So right now they're focusing on a lot of procedural stuff. Like you mentioned earlier, trying to bifurcate Donald Trump's trial against the other defendants because none of the other defendants will be served well to be tried with him. But this is a RICO case. So judicial economy is very important since it's going to be a very lengthy trial. And Willis, the prosecutor for this case, has done a prior RICO case in 2014 where she gained notoriety for it in the Atlanta public school cheating scandal.
Yeah, that's true. She really kind of forged new territory. Again, we were talking about the RICO Act earlier, how it has begun to see expansion in where it's applied. And certainly this case is one. The Young Thug case is another. Not your traditional mob case, which in 1970 the whole act was created to pursue. So we're going to go back in. We're going to go live into court now. Again, this is Fulton County, the courthouse there in Georgia, the case against Donald Trump and a number of other defendants. But his team making arguments that the case should be dismissed against former President Donald Trump for First Amendment reasons. Let's go live.
Political speech. If you look at the indictment, what it says in its introduction, it tells us what the state is targeting. It says that Donald Trump lost the presidential election on November the 3rd. One of the states he lost was Georgia, and Trump and the other defendants charged in this indictment refused to accept that Trump lost, and that they knowingly and willfully joined in a conspiracy to unlawfully change the outcome of the election. So what that tells us, and what the entirety of the rest of the indictment says, is that the state is attacking the challenges, speech, concerns, and efforts that the defendants here took with regard to their belief in the 2020 presidential election. The state wants to jail the defendants, and it tells us this, for not accepting those results, for not accepting that President Trump lost, and for not agreeing that Georgia's vote counting process was pristine. According to the state and its indictments, any and all challenges that the defendants made, any and all legal theories that they came up with to support their position, and all discussions that the defendants undertook discussing those positions are knowingly and willfully false. And the state says that, and we heard this with regard to the ECA because the state says it. And the state says that speech to the contrary, that the election had a problem, that there were vote counting issues, or anything else, the state says that that is prosecutable. And that is the problem. The indictment is seeking to prosecute the defendants with regard to the political speech. And the fact that it's political speech is extremely important here. And when you go through the indictment, and I did, and you look at every single count that relates to the defendants that are sitting in this courtroom or the lawyers that are, you look at every single act of the indictment that supports count 1 in the RICO case, all of it relates to speech. They say in pages 16 to 17 that talks about the methods and manners of the RICO enterprise, that it is the problem is that the defendants spoke to Senate legislators, high-ranking government officials, the courts, Justice Department officials, and the Vice President of the United States to plead their case with regard to the 2020 election. They say that the defendants made statements regarding the presidential election in courts, on television, voicemail, press conferences, and with public officials at subcommittee meetings in front of the Georgia General Assembly. And that's noted in the materials that I gave you. They attempt to preserve a challenge to the 2020 election by voting for the electoral slate. They say that that's a violation, even though Bush versus Gore allows it in the ECA. But it's a challenge. It's an electoral challenge to what was going on in this state very shortly after the election occurred. And they say that raising concerns of the election process before these subcommittees were criminal in nature. Every single count, and if they can show me something different, they can get up here and do it. But every single count of the complaint, every single act in the indictment relates to that political speech regarding probably the most important election in 2020, the presidential election. And the state does not attempt to, in its briefing or anywhere else, argue that it is attacking anything other than political speech, nor could it credibly do so, because all of the speech that was made related to the propriety and outcomes of the presidential election. Here, there is no allegation of bribery. There's
All right, so here we go. Natalie, let me ask you before we head into the top of the hour break here. This is a big difference between arguing facts and arguing law. Explain what the judge has to do in this case.
I mean, the judge has determined, taking the case in the light most favorable to the prosecution, is the indictment lacking in showing that there was a crime that was committed, or is it somehow unconstitutional, the law that they're relying on? And these arguments don't go to that. These arguments are forcefully putting forward Trump's defense to the prosecution's case. And so I don't think that the judge is left with any choice but to find that the demurrer should be denied and the case should go forward to trial short of some type of resolution between the parties.
And you wonder maybe if there's a little attempt to kind of get this argument out in front of the public, kind of get the jury kind of conditioned to what they might expect in a real trial. But it's happening, and we're going to continue to cover it. I'm going to thank and excuse Natalie Whittingham-Burrell. She's in the heart of it there in D.C., not where this case is, but everything else was happening. And we're so glad to have you on and discuss this case. We will see you next time. Have a great weekend. I will be back, and Katherine Lizardo will be back, and we will be back in that Atlanta courtroom when we come back to Law and Crime. Stay where you are.